All right, let's get into this because what's happening with Melania Trump right now is genuinely unreal. And it's one of those stories that sounds absurd until you realize it's all happening in black and white court filings. Here we are again with the same pattern we've seen for years. Melania Trump, the famously elusive former First Lady, is doing everything humanly possible to avoid being served legal papers. And I don't mean a little delay here or there. I mean full-on, Olympic-level evasive maneuvers. We're talking about dodging process servers like she's in the ring with Mike Tyson in his prime, slipping punches, changing locations, disappearing at just the right moment. Every time someone gets close enough to legally hand her the documents, she's suddenly gone. And this isn't accidental. This is deliberate. So why is she running? Why all this effort to avoid something as basic as service of process? It all comes back to a journalist named Michael Wolff and a legal battle that Melania is desperately trying to control before it ever really begins. She has filed, or rather threatened, a staggering $1 billion defamation lawsuit against him. And now that Wolff has pushed back in court, she's trying to slow, stall, and derail the entire case by claiming she hasn't been properly served. And here's where things get interesting. Because just in the last several hours, Melania Trump filed a brand new letter brief in federal court in New York. This is not old news. This isn't something from weeks ago that's being recycled for clicks. This literally just happened. In this filing, her legal team lays out a series of complaints, but when you strip away all the legal fluff, her core argument is painfully simple. She says the doorman at Trump Tower was served, not her personally, and therefore, in her view, service is invalid and the case shouldn't move forward. That's it. That's the hill she's choosing to die on. The doorman got the papers, but they weren't physically placed into her hands. So according to Melania Trump, the lawsuit doesn't count. But here's the obvious question that her filing conveniently ignores. Why wasn't she personally served? And the answer seems pretty clear. Because she's been actively avoiding service. This isn't speculation. This is pattern behavior. For months now, Melania has been bouncing around like a pinball between Mar-a-Lago in Florida, Trump Tower in New York, Bedminster in New Jersey, and occasionally the White House when it suits her. Just as process servers show up at one location, she's already moved on to the next. It's like a shell game, or better yet, a mobile missile launcher that never stays in one place long enough to be targeted. And while that might work in movies, it's not a legitimate legal strategy in federal court. What Melania and her legal team are either pretending not to understand or hoping the judge overlooks is that you don't get to evade a lawsuit just by dodging the mailman. Federal courts have dealt with this exact behavior countless times. When a defendant deliberately avoids service, judges have options. They can authorize alternative service. They can allow service through counsel. They can approve service by leaving documents with someone at a defendant's residence. They can even allow service by publication or electronic means. The idea that you can just keep moving and freeze a lawsuit indefinitely is a fantasy. And that's why this filing feels less like a serious legal argument and more like a stalling tactic. Because buried underneath the service complaints is what looks like the real objective. Melania isn't just trying to get this case dismissed. She's trying to move it. Specifically, she wants it out of New York and transferred all the way down to the Southern District of Florida. And if you've been paying attention, you already know why that matters. Because if this case lands in South Florida, there's a very real chance it could end up in front of Judge Aileen Cannon, the same judge who has repeatedly issued rulings favorable to Donald Trump, including dismissing his classified documents case. That's not speculation. That's geography and judicial assignment math. And when you look at Melania's legal strategy through that lens, the entire game becomes obvious. This whole dance about improper service starts to look like a setup, a delay tactic, a way to argue procedural issues long enough to justify moving the case into friendlier territory. And that's what makes this so fascinating, because it's not just about whether Melania was served correctly. It's about where this fight will be decided, and more importantly, who will be deciding it. But to really understand why this matters, we need to rewind and talk about how this all started in the first place, because the origins of this case explain why Melania is so aggressive and why Michael Wolff didn't blink when he was threatened with $1 billion lawsuit. That's where things get even more explosive. All right, let's pick this up right where it gets even messier, because the backstory here explains exactly why Melania's legal team is scrambling, and why this case has turned into such a high-stakes chess match. At the center of all of this is Michael Wolff, a journalist who has spent years reporting on Donald Trump, his inner circle, and the ecosystem around them. Back in October, Wolff received what can only be described as a legal threat designed to intimidate. It wasn't subtle, it wasn't cautious. It was a demand letter sent on official legal letterhead from Alejandro Brito, the same lawyer who represents both Donald Trump and Melania Trump. And the demand was jaw-dropping. They wanted $1 billion, not millions, not tens of millions, $1 billion. The letter accused Wolff of defamation and demanded retractions and apologies for a list of statements connected to reporting that had appeared in outlets like the Daily Beast and elsewhere. Those statements centered on Wolff's investigative reporting and commentary, including remarks he attributed to Jeffrey Epstein, connections between Epstein and the Trump world, and broader reporting about Melania's background in the modeling industry and the social circles surrounding Trump at the time. Some of it was direct reporting. Some of it was analysis. Some of it was contextual commentary. But none of it came out of nowhere, and much of it was tied to information already in the public record. Still, Melania's legal team treated it like an existential threat and responded with the legal equivalent of a nuclear weapon. Now, here's where Wolff made a very smart move. Instead of folding under the pressure of $1 billion threat, he went on offense. In October, before Melania ever formally filed her defamation case, Wolff filed his own lawsuit in New York State Supreme Court, which, despite the name, is actually the trial-level court. And strategically, this was a brilliant decision. By filing first, Wolff seized control of the battlefield. What he asked for wasn't damages. He wasn't suing Melania for money. He was asking for a declaratory judgment, which is essentially a request for the court to officially declare that the statements at issue are either true, protected by the First Amendment, or not legally defamatory as a matter of law. He also asked the court to declare that Melania's $1 billion threat constituted an unconstitutional attempt to chill his free speech as a journalist. In other words, Wolff wasn't just defending himself. He was asking the court to say out loud that this kind of legal intimidation has no place in a democracy. That move flipped the script completely. Suddenly, Melania wasn't the aggrieved party seeking justice. She was the defendant, being dragged into a forum she didn't choose, forced to respond to a case that put her legal strategy under a microscope, and she clearly didn't like that. Here's a crucial detail people often miss. Filing a lawsuit is not enough to officially start it. You also have to serve the defendant, meaning you have to formally notify them by delivering the legal papers in a way the law recognizes. That's where Melania's vanishing act begins. According to court filings, process servers attempted to serve her at multiple locations over a period of months. Trump Tower, Mar-a-Lago, other known residences. Every time she was conveniently unavailable, always just gone, always one step ahead. And now, in her latest filing, she's trying to turn that evasion into a weapon. She's arguing that because she wasn't personally handed the papers, the court lacks personal jurisdiction over her and the case must be dismissed. But here's the problem with that argument. It collapses the moment you apply common sense and established law. Courts don't reward people for dodging service. In fact, they do the opposite. When someone actively avoids service, judges can authorize alternative methods: service on a doorman, service on legal counsel, service by mail, publication, or even electronic means in some cases. And in this situation, Wolf's legal team didn't just leave papers with a random person. They served the doorman at Trump Tower, a residence tied directly to Melania, and they sent copies to her attorneys. The idea that she somehow lacks notice of the lawsuit is laughable, especially considering she's now filing documents responding to it. And that opens the door to another powerful argument Wolf's lawyers are almost certainly going to make: waiver. If you're actively participating in litigation, filing motions, and arguing about venue and jurisdiction, you can't simultaneously claim you don't know about the case. Courts see right through that kind of contradiction. But Melania's legal strategy doesn't stop there. Her team also argues that New York courts don't have personal jurisdiction over her at all. And this is where the argument veers into the absurd. Melania Trump spends a substantial amount of time in New York. Her name is literally on one of the most famous buildings in the city. She shops there, attends events there, maintains a residence there, and most importantly, the allegedly defamatory conduct is tied directly to New York, where the demand letter was sent and where Wolf lives and works. Legally speaking, that matters. There are two types of personal jurisdiction: general and specific. Even if Melania tried to argue she doesn't live in New York full-time, the events giving rise to the lawsuit clearly have strong New York connections. That alone can establish jurisdiction. And by raising this argument, her legal team may have just opened the door to jurisdictional discovery, which would allow Wolf's lawyers to dig into exactly where she lives, how much time she spends in each state, and where her true domicile actually is. That's not a door you open lightly. And then finally, we get to the part that really gives the game away. At the end of the filing, almost as an afterthought, Melania's lawyers argue that if the case isn't dismissed outright, it should be transferred to the Southern District of Florida. That's the backup plan, the escape hatch. And it's no coincidence, because down there, the pool of judges is small, and the odds of drawing a judge sympathetic to the Trumps suddenly look a lot better. This isn't random. This is calculated, and once you see it, you can't unsee it. Now here's where everything comes into focus, because once you step back and look at the full strategy, it becomes clear this isn't just about service papers or jurisdictional technicalities. It's about control, delay, and steering the case toward the most favorable terrain possible. Melania's legal team is running a layered defense designed to exhaust the process before it ever reaches the merits. First, deny proper service. If that fails, deny personal jurisdiction. If that fails, push for transfer. Each step buys time, burns resources, and increases the odds of landing in a courtroom where the outcome feels safer. This is not unusual for high-powered litigants, but it's revealing when combined with the scale of the original threat. You don't threaten a journalist with a billion-dollar lawsuit and then act surprised when the legal system pushes back. The push to move the case to the Southern District of Florida is especially telling. That district has only a handful of judges covering the relevant area, and one of them has already demonstrated a willingness to interpret the law in ways that consistently benefit Donald Trump. While no judge can be handpicked, narrowing the venue dramatically improves the odds. That's the gamble, and it's one courts are very familiar with. Federal judges know when venue arguments are being used not for convenience, but for advantage. And they don't always look kindly on it, especially when the alternative forum has such an obvious political and personal connection to the defendant. What also stands out here is the contradiction at the heart of Melania's position. On one hand, her lawyers argue she has no meaningful ties to New York. On the other, they acknowledge her name, brand, legal actions, and alleged harms are deeply intertwined with events and communications that took place in New York. You can't simultaneously claim distance from a jurisdiction while invoking its influence when it suits you. Courts exist precisely to resolve those inconsistencies, and when defendants try to have it both ways, judges tend to notice. There's also a deeper issue that cuts beyond this single case, and it's the one that makes this fight matter far more than Melania Trump versus Michael Wolff. This is fundamentally about whether wealthy and powerful public figures can use overwhelming legal threats to silence journalists, then hide behind procedural games when challenged. Declaratory judgment actions exist for this exact reason. They allow speech to be tested in court before intimidation succeeds. They prevent the chilling effect that comes from the mere threat of financial ruin. That's why Wolff's lawsuit isn't some legal trick, it's a shield. And courts have repeatedly recognized that shield as essential to a functioning press. The irony is that by trying to crush Wolff with a billion-dollar demand, Melania's team may have created a much larger problem for themselves. They've invited scrutiny not only of the statements at issue, but of their litigation tactics, their venue shopping, and potentially even their claims about residence and jurisdiction. If jurisdictional discovery moves forward, uncomfortable questions will follow. Where does Melania actually live? How often? Where are her primary interests centered? Those answers won't be controlled by press releases or legal posturing. They'll be grounded in records, calendars, travel logs, and testimony. And that's the risk of overplaying your hand. What began as an attempt to silence a journalist has evolved into a public examination of power, privilege, and accountability. Judges don't operate in a vacuum. They understand context. They understand strategy. And they understand when the court system is being treated as a tool rather than a forum for justice. So now the case sits at a critical juncture. The judge will have to decide whether service was sufficient, whether New York has jurisdiction, and whether this case stays where it was filed or gets shipped south. Each decision shapes the future of the litigation, but none of them erase the central issue. A journalist reported on powerful figures, was threatened with annihilating financial consequences, and chose to fight back using the Constitution itself. That's not noise. That's a stress test of democratic norms. This isn't just a legal dispute. It's a signal about how power reacts when challenged, about how the courts respond when procedure is weaponized, and about whether the First Amendment still has teeth when the people on the other side have unlimited resources. The answers won't come overnight, but they will come through filings, rulings, and records that don't forget. If you want to understand how these cases really work, how strategy hides inside procedure, and how the law becomes the battleground long before a verdict is ever reached, stay with this story. Subscribe, follow, and keep watching closely, because the most important moments in cases like this don't happen in headlines. They happen quietly, on paper, and by the time everyone notices, the direction has already been set.